Today, more than ever, HR professionals need to stay in the know to remain compliance and culture savvy. This podcast is about creating space for HR professionals to make sense of that delicate intersection and take away something valuable that helps you, your organization, and of course, your people. We'll unpack state and federal legislation, agency activities, court decisions, and so much more impacting the HR community right now. Here comes a disclaimer. Go ahead and read that. These days, you've got to be careful. Okay, that's good. You're getting it in. Now, let's get this conversation going. I'm your host, Tracy Justice, with co-hosts Rachel Guin and Chris Schrader. Who's your HR? Let's go.
Cool intro. I like that. I especially like the fact
Super cool.
Well, I liked it that you threw in our chapters on the disclaimer because I wasn't even thinking of that until I read it.
Well, just because, and because I want to be fair that, we're not SHRM sponsored. However, right. I am very grateful, for the opportunity, me coming into NIHRA and you all coming into Rachel, NIHRA, and Chris, you with SCIHRA, that, I know that you all might become, well-known, you're well-known in your communities. And I definitely don't want anybody to hear what we're saying on here and say, well, SCIHRA or, or SHRM or NIHRA, so I just wanted to make sure that, I was fair to that, but super cool. So you like the new intro to rebrand the show? It's just later on, it's going to be B-roll, but for now it's
graphics. Yeah, good graphics, different music. The disclaimer was good.
Wait till the end. The end's funny.
We have an end cap. Okay, cool.
Oh yeah, the outro's even it's extra. But I'm really excited because we I know that we've been kind of out for a little bit. The last time we did a podcast was in December, and so much has happened since then. But I also think that we have some time to kind of see how some of those things have landed. And so before Rachel, how are you doing? And then Chris, how are you doing? And before we go ahead and get started.
Doing fine. Business is really busy. I mean, really busy. And then, of course, I'm teaching at IU. And so class students just had their first graded element, and they are not going to like the results. And so that'll be an interesting evening tonight. But it's
hopefully they're not watching this and find that out.
They've never done cases before, so they struggle the first time. And that's the nature of it.
I'm doing really well. Thank you for asking. My firm just merged with Krieg DeVault, and so there has been a substantial learning curve, a lot of training, new technology. I'm really excited about all of the AI opportunities that I now have through Krieg. It makes me nervous, but I'm learning. And obviously, I have a deep bench of colleagues who can now help me on projects that I didn't have in the past. So very good stuff, but change is always hard. And so, I think in 6 months I'll feel a lot more settled. Right now, I just feel like I'm a hamster in a wheel, trying to figure everything out.
So you've done the cut over to their system.
Oh yeah.
Yeah, that's always adventurous.
Yeah.
And then AI. So the AI helps with cases and study, research, how does AI help you or help the organization?
So our it's Westlaw, it's Thomson Reuters product, and it's a very common research tool. So typically you use Westlaw to pull up a case, and it had some AI features before, and then the case you kind of dig through to find what you're looking for. Now I type in what my question is. For example, if an employee has reduced their hours and are no longer eligible for health care pursuant to the ACA, but they are on intermittent FMLA, do I still have to provide them with their health care? So if an employee were on extended leave, the answer is yes. Yeah. What I don't know is if they're on intermittent leave, and the reason that they're reducing their schedule has nothing to do with the health issue they're having or a disability.
Oh.
Right. So we're talking about two different things.
Oh.
Technically, the FMLA says if an employee is on FMLA, you must continue to provide the benefit.
Right.
But does that account for intermittent leave? So plug that question in. I have an associate doing that work for me now.
Yeah, I was just going to say that's complex, because if that intermittent FMLA is not tied to a medical condition, it's a different. They're qualifying on a different piece of it.
Well, the FMLA is tied to the health condition, but the reduction. But the reduction in hours is not.
Oh,
you know what I'm saying.
Oh.
So let's say an employee is maybe having childcare issues and needs to cut their hours back to 25 hours, but at the same time they're on intermittent FMLA leave for a healthcare issue. It's kind of.
And then the combination of the two is what's trigger. Okay, I get it now.
Yeah.
Oh, wow.
Wow. No wonder they called you.
Yeah, well, it's an interesting question, and
yes,
so
it is.
One of our associates and I are kind of going back and forth and pushing back on her a little bit.
Sure.
Yeah, it's just a unique fact pattern. So, yeah.
But that's nice that it sounds like it's really improved the quality of the search function.
It has. And so what it does is it gives you a summary of an answer and then identifies the cases that it used to come up with the answer. So you can double check it, which you should. And you can designate where you want the cases from. So, for example, I want to know what the Seventh Circuit says, right?
Mm-hmm.
That appellate court area that we fall under, because I want to know how they're reviewing those issues right now. And that could be different than the Sixth Circuit, so which is like Ohio or whatever. So yeah.
Okay.
Well, it's interesting.
No, so Chris, then,
yes.
Then how would you, if you have a situation like this where, maybe they didn't call their counsel, but they call you because you're the HR consultant.
That happens all the time.
So would you be able to do what Rachel? Like, how would you do what Rachel did without that system? Do you have a system? Let me know about the system.
I'm not an attorney, and I don't have access to. I don't have access
to that kind of stuff.
So a lot of these systems I don't have, and normally what I would do. Well, I'll give you a real good example. Like in my current practice, I'm working on I'm doing an investigation to support what's going to end up being a response to an EEOC claim that's made. Now, I'm going in and gathering all the data, reconciling the fact pattern, doing all that sort of stuff. And then I'm going to turn it over to an attorney to write the response to the EEOC, right? Because I want somebody that's got experience doing that. And then my rationale to the client is, I'm cheaper than the attorney. And there's going to be stuff that's going to have to be done on the backside here because, Rachel, as you can imagine, there's
I know she's going to charge you.
I've got a cost issue of really, really good facts and some bad facts. And I've identified some practices that are going to have to change because of the vulnerability. The council may or may have not done right in all of this. So it's not unusual for me to carry the ball to a certain way, and then I'll go to the client and say, okay, let's bring counsel in and let's work through this piece of it, and this piece over here is tied to your CPA because you got this tax you over that, and then I've got an ERISA vulnerability. I think I've identified here. We're going to need an ERISA attorney for that. So usually what I go in and do is, from the HR side, analyze the exposures. And then when it gets to where a level of expertise is needed that exceeds my own, that's where I'm going to say, and that. So on this particular case I'm working on right now, the first question I asked them, do you have counsel, or do you need me to refer? And they said, no, we have counsel. And I said, what kind of counsel? And so they told me.
Okay, why did you say what kind of counsel? Why?
Well, not everybody has
employment law
practice, right? That's correct. Yeah.
Oh, okay,
Especially in small towns like Bloomington, right? For instance, there are employment practice attorneys in Bloomington, and I know every blessed one of them. We're that small. Right? So,
really? I went to Bloomington a few years ago. Go ahead, Rachel. I'm sorry.
Even in the city of Fort Wayne, we have 6 or 7.
Yeah.
Really?
So, yeah.
Yeah.
Is Fort Wayne big?
I mean, it's the second largest city in the state. So our
6 or 7 is
third, right? Yeah.
There's not that many lawyers here in the state of Indiana? Like employment lawyers?
Law,
employment law.
Side.
Yeah.
It's just very specialized.
Correct.
Really? I didn't.
Attorney in the
Yes. Oh, yes. And ERISA, even more specialized. Even a big firm like Krieg probably has only got like one ERISA attorney, maybe two.
We've got a couple. Yeah.
Yeah. Okay. So you're big enough.
No, I kind of like that. I like that. Rachel's like, no,
but my point is
the
the law firm they're using here in Bloomington does not have an ERISA attorney, which didn't surprise me.
Yeah.
Right. I mean,
so interesting.
Yeah.
It's a subspecialty, right? I mean,
yeah, it is.
And I think that's why I find this. Go ahead. I'm sorry. Go ahead, because they're
no. They're very expensive because it's hard to find them. Yeah. Yeah.
Really, ERISA attorney. Okay.
It's niche, and ERISA is just a bearable law, and you get sideways of that, and it's easy to crank up significant costs, fines, things like that. So yeah, it's ugly. But yeah, mostly what I do is go in and kind of narrow it down, and then make sure we've identified things the correct way. And because a lot of times I think an employment side attorney would certainly look, but a lot of times attorneys, they don't, unless they're like Rachel, they really don't know what we do in HR. they just
you
don't.
know what? And okay, that is very helpful because I did look at a case recently. I'm not going to say too much about that, but an attorney did the research or did the workplace investigation, but it didn't really seem like they understood HR laws. So some of the things that they were talking about in there, I was kind of like, it's so interesting. Where was HR? You say, well, that's why it's like, who's your HR? It's like, what? Like, what happened there? But that's
at one corporation.
That is so good to know for HR people.
Yeah, at one corporation.
That's why. Okay, go ahead. Okay, I'm so excited because we're back.
The attorney that the CEO directed me to work with, because he knew this guy and he was really smart. So he said, "You're going to work with him." I call the guy up, and he's an intellectual property attorney.
Oh, geez.
And no. That's what I said, Rachel.
Very smart.
Now, what did you say? Very smart, but
super smart, and told me right off the bat, yeah, I don't have a clue what you're talking about. I
see,
don't.
and well, you know what?
He said straight up, I'll tell you, I know we covered that in law school at some point, but that was 25 years ago, and I don't remember a damn thing.
Well, and frankly, they don't cover it in law school unless you take it as an elective. So employment law.
Oh, really? Oh, I didn't realize that. Oh, you have to take it as an elective?
It's an elective. Wow, so many people go through law school and never touch employment law at all. And so it's a second or third year course you can take. And I had a situation come up about 2 years ago, and this is an attorney who passed away recently, that he wrote an article for, I want to say it was like for a Business Weekly, maybe, here in Fort Wayne. And in the article, he wrote about final paychecks, and that like if an employee doesn't return company property, you can withhold the last paycheck. And I was like, oh God, no. So I called them and I said, hey, he's not an employment attorney. This is bad legal advice. Like, get people sued. and they were like, well, can you help us fix it? I'm like, yeah, I guess let's think strategically about how to do it without being offensive. But so I ended up then writing a larger article that included something about withholdings. I did an income withholding just discussion generally. What's tolerated, what's not, and so we kind of corrected it. But I mean, it can be really bad.
It makes sense.
So
it makes sense. And, and this is another reason why, I want to be intentional about creating this space, because I think that when we talk about employment law, I don't know, but I don't really feel like a lot of HR people really understand the employment law portion of it, or at least decisions that are made, especially how decisions are being made so quickly. today, and then not knowing or not realizing that not every attorney is an employment law. I mean, I think that's
Well,
common sense, but to know
we
that not every attorney has that niche. So then
have
you
to
want to make sure you're asking clarifying questions on that before you just say, hey, come
right.
be my counsel.
I think that's a good call out, Tracy, because we have to remember too that our profession specializes also. I just had I did a lecture series on recruiting for my class, and I had one of my former students who's now a director, North American director for talent for a very large British conglomerate. And I had her on Zoom, talk to class, and I had given them her LinkedIn profile ahead of time so they could kind of see her career arc. I remember I had her as a student, very, very sharp. But all she ever wanted to do was recruiting. She just fell in love with it. She took that after my class. She took that class, and that's a required class for the HR major at IU. And she got an internship at that company in recruiting and never left. So she's been in that recruiting channel her entire career. And there are people that do that. We have subspecialties in HR, right? There are folks that go into comp and ben. There are folks that go into safety. I mean, there's all kinds of certain things. And oftentimes in larger corporations, your employee relations people will probably be pretty darn versed, right? Folks involved.
I think I like that kind. I like employee labor relations
in selection, not necessarily recruiting, but folks involved with selection will probably know quite a bit, and generalists will know. But there are big pieces of HR practice that they're kind of like the lawyers, Rachel. Yeah, I took a class at IU for a professor, on this sort of stuff.
Yeah, like I passed my certification, so I understand.
Yeah, I went to recruiting. I don't remember any of that.
Yeah. Yeah.
So it's really interesting. So I just kind of wanted to talk a little bit about that because I just found it really interesting to hear. I think that especially Rachel, when you said 6 or 7, I was wow. I think I'm really thrown off by that. Interesting, because I just didn't realize that it wasn't that. Something to question for sure. So some of the things that I wanted to I wanted to talk about today, and then I want to hear if there's anything that you wanted to talk about. So I tracked some of the Indiana General Assembly bills. I tracked there was about 742 bills. Okay, because I know Chris, you kind of talk about that.
Yeah.
Is that small? Was that small? A lot? What do y'all think about that number for this session? Normal?
Normal for a short. So remember
normal for a short. Okay.
The shorts. First of all, legislators always receive limits on the number of bills they can draft, depending upon how many bills they can draft, depending upon how the leadership is thinking that the session is likely to shape up, how much time and how much effort is going to go into the priority bills. These are always the bills that are 1 through 10, right? So the majority caucus gets to set the table on that. And so the first 10 bills are always the ones that are going to get all the love and the attention, the ones that you expect to pass. And they're going to get those across the finish line pretty much come hell or high water. And so if they just take more time, that's it. And so the legislators in this session, I believe, the House was limited to 4. Maybe they got 5. It was 4 bills. So if you're in the House of Representatives, that means you could offer 4 bills.
Per person, right? Or you mean per
person, per legislator?
Oh, okay. Per legislator. Interesting. Is it always 4?
No, it can vary. In the longer session, I think they get 6. But this session was really odd. Remember, it started out with.
Oh yeah.
Okay, so then they made the decision. So after they did that, they were like, okay, we aren't willing to spend any more money than we had budgeted for a session, so we're just going to keep on going. So this whole thing was funky from the beginning, right? And so that factored into the number of bills you could write. Also, this is not a budget year, right? And so that changes the That changes the tenor and the type of the bill that's going to be offered, et cetera. You aren't going to see any bills that touch the budget, require funding, require change in taxation, blah, blah, blah. That's all going to be in the next session. The Democrats did ask that the budget be cracked open in this session. They had a number of what are referred to as affordability bills. Affordability is a big issue. And the Republicans said they were not going to open the budget. That's pretty much Constitution says you do that every 2 years and that's it. And they hung their hat on that.
Oh, okay.
They're doing. So not that I blame the Democrats for trying.
Well, the same thing with the redistricting, right? They said that we don't do this. This is what we do. This is the process.
Well, yeah, I told you from the beginning that wasn't going to go. I mean, you didn't need a crystal ball for that one. I mean, it was straightforward. But
I was just curious about that. The bills.
So at any rate, what did happen? So you had a lot of bills that died, right?
Yes. Out of the 39. There's only 13 still active from that list, and it could have changed today.
I'm shocked that it's 13, right? Because there's always a bloodbath when you're coming to the midpoint because the bills have to clear their house of origin, right? And so you get this huge competition for very scantily available hearing hours. And bear in mind, we do not have a full-time legislature, right? So these people have jobs. And so making sure you have a quorum, not everybody is there all the time. That's why you see these votes kind of fluctuate because they voted on a day when a lot of people just couldn't make it there. So it passes, but you see the vote totals are different. Okay,
because I do see the vote totals for some of these. So let me ask you this, Chris. Did you kind of get a chance to look at the bills?
No, I didn't. Recently, what are the 13 that are surviving? What's the one that worries you the most?
Well, the ones that are surviving, I don't think I'm really well. Okay, let me see if there's one that's really worth talking about. Maybe
is the workers' comp. Did that one survive?
Which one? Which number is that?
It is HB 1069. So choice of physician for worker injury or disease.
Okay, good. That's one of the ones I wanted to talk about. It did not survive, but I was curious, like the thought process even behind that. Like, what is that?
Go ahead and take that. I'm familiar with that bill. Go ahead and take it.
Yeah, so it's a choice of physician for worker injury or disease permits an employee to choose the attending physician who will provide services and goods resulting from an employment injury or occupational disease for purposes of the workers' compensation law. So as it stands right now, Tracy, if you are hurt at work and your employer is on the hook for the injury, they get the right to choose the physician that provides the care. So typically you're hurt at work, we're going to take you to whatever our local occupational health is, assuming the injury isn't like an ER visit, maybe a back sprain or something. So you're going to go to our doctor and we're going to approve the care. And very often we're going to hire someone called a nurse case manager that's going to oversee the care. They'll go to the appointments with you. You can ask that they not be in the room. Right. After the visit is over, they will communicate with the physician. They're going to approve whatever recommendations the physician makes, whether that's X-rays, an MRI, physical therapy, all of those things. But if the employer is paying for it, under the current work comp law, the employer has the choice of who you go. So what this suggested was that it would be the employee's decision of which physician they go to. Now, for an employer, that's a big problem for a lot of reasons. Because what if you've got a pre-existing injury? What if your doctor is your friend? There are a lot of ways to manipulate the system, and we see that sometimes when people go to their own physician and they come back and they say, well, my doctor said X, Y, Z. Yep. And typically, if you do have a good relationship with your physician, they're not going to push back a lot if you're saying, hey, I'm having this lower back pain, and they don't have any reason to question you or understand.
They're not usually not occupational docs. I mean, that's not a small thing.
Right.
Okay.
And
Okay.
typically we're all, we're normally working with specialists too that are appropriate in that area. And so, so this would have been a big deal. I'm not surprised that it died. I can't imagine.
Yeah,
that
the chamber opposed it. I didn't think that thing was going to move, especially in the short,
Yeah.
And it did that even get a committee hearing?
Because
I don't know.
Because it came in December, like it was introduced in December, so it seemed like
that's okay.
No, not at all.
Did that go to?
It was just introduced.
Insurance.
Well, Chris, it was introduced, so it wasn't. So it was just introduced. That means it wasn't heard, right? Am I understanding that correctly?
Well, everything has to get introduced, get heard. I was just wondering how deep it made it in the process. I would expect. The committee that got referred to, if it went to the right committee, which it usually does, I can imagine that they were that committee chair would be less than enthused to hear that. I don't even think it came. I don't even think it got.
Okay, so then that's a good bill to kind of track.
All of the reasons
to see.
Every reason that Rachel out there is why you don't want to do that. I would also put in the caveat that even though that everything Rachel said is 100% true, the employer, if the employer permits employees to go ahead and do it,
that's okay.
Then they will, right? As nuts as that is, I did come to work at a company where they had allowed that, and one of the first things they told me when I came to work was that the workers' comp claims were just through the roof. No kidding. And I immediately started digging in and found out that a bulk of the claims occurred between somewhere in the first half hour of the first shift on Monday, where apparently our factory was the most dangerous place on earth. And the employees were all going to the same doctor, all of them. And
I mean, it's not funny, but
what we gave them, so his standard of practice was to give them 5 days off. So that was just like automatic with him. You get 5 days off.
Oh, that's a benefit. Workers' comp is a benefit at this.
5 days vacation, and he gave him 30 days of Vicodin, a freaking class 1 narcotic, right? And when I found out, I just went ballistic, because at first I was terrified that the workers were taking the drugs. It turned out they were only selling them. So I had a secondary drug market operating.
Wait a minute.
The factory whereby they would get the drugs and then sell them rather than consume them themselves. And so I altered that arrangement and got a handle on that. Took some firings to really wring it out. It was a really difficult situation, but that underscores why it's so important for the employer to pick.
Well, and
so it totally makes sense, because when I saw the bill, go ahead, Rachel.
I was like, I'm gonna branch off just a little bit. I've got a client who, it's a union shop. The employees all go to the same physician. And they had an FMLA issue. So kind of what Chris was dealing with in this instance, it was FMLA abuse. And
being water stamped. Yeah.
And so we finally said, okay, let's get them all out. I want to see the large majority are signed by the same physician. Many of them are for like neurological disorders, cardiovascular type diseases. And this is a general practitioner signing off on these. And this is where you've got to have an HR team that is either properly trained to manage these things, an attorney on call who can review them as they're coming in, or work with a TPA to manage your FMLA.
Correct.
Because if you are not taking the time and you don't have the skill set to look at this and understand what it means and what your rights are, you're really opening your company up to liability and exposure. And so what should have been happening as this is coming in, family physician says, oh, this person has XY neurological disorder, and here's the intermittent FMLA they need, because of course it's typically the intermittent, so they can go home whenever they want.
Correct.
Yeah, and these people don't like working Fridays and Saturdays, and so they just intermittent.
Of course, or Mondays.
Those are
Yeah.
brutal days.
Yeah, and so as an employer, but the timing of this is extremely important, because you can only challenge that FMLA certification when you get it.
Correct.
If it re-ups for the exact same condition, you have foregone your right to challenge the certification. And so it must be done right away, unless there are a few caveats to that, but we won't get into that right now. So what should have been happening is they should have been taking these and saying, we are going to send you to our neurologist. We are going to pay for it. It's our responsibility, but we're going to get a second opinion, because we don't think general practitioner has the skill set to do this, right? And it's one of those situations where you really got to take control of it right away. And then lo and behold, many of these people were not actually eligible for the FMLA. And we were able to clean it up over time as we, dealt with situations as they came in. But, it can become, especially for this client, just extremely disruptive to their operations.
There's nothing worse than everybody. But the thing that I want everybody to really pick up on what Rachel said, you've got to get on this immediately. You have to review those forms as they come in, and if you think they're defective or you're seeing pattern or
challenge
something
it then.
like that, yeah, that's when you got to get on. I had a situation at an employer where it was from this one doctor, and to me, they appeared to be the most outrageous types of FMLA accommodations, the intermittent and, all this other stuff. And I started noticing, one of my people flagged it, and I started looking at these things, and I'm like, okay, do we have others? And I started recognizing great variation. First of all, the forms were always filled out by hand. There was no typing, no computer. They weren't doing a PDF or anything. It was always filled out by hand, and the handwriting was invariably different. And so I'm thinking, okay, so either his doctor's got high turnover or something like that. Come to find out that the doctor's position was that he hated FMLA. He hated it, and what he did, it's not that he
be able
did
to get off when you want to.
He said his point was, this is all uncompensated work for me. I didn't ask for it. The government passed this thing. I don't get to charge for it. I don't get to do anything. It is a giant pain in the neck for me. So his tack was, when when people came in and said, I've got this FMLA form, he told them to fill it out and give it back to him.
Oh, okay.
He just washed his hands of the whole thing. It's like, this isn't on
They don't get paid for that?
No, it's uncompensated. I mean, the smart ones pass it through, for Pete's sake. I mean, up your rates a little bit, Chief. But I'm sure he was on, he's on a PPO contract. He can't push it anywhere, right? So yeah, but when I called him up, he was like, yeah. I mean, he copped to it right away.
Well, then, Chris, let me ask you this. So then, did they have an HR, and Rachel, for you too, like, in those situations, do those clients have an HR department?
This client did, but I'm going to say that the person who was in the role at the time had been there for several years and did not have the proper skill set for the job. Was more of a generalist than a director. And another thing that we learned in that situation, and it comes up really with a lot of my clients, when people are using intermittent FMLA, every time you get that call, you've got to pull the paperwork, right? So you got to get it back out, because people will be like, well, they called and said intermittent FMLA. And I'm like, who did they tell that to? Well, their supervisor. Well, what's the reason for it? Well, I don't know. They said intermittent FMLA. Okay.
Like it's a magic term. Yeah.
Yeah, that's not good enough. That's not good enough. So
it's not good enough.
They need to contact HR. So, we now have, and this is something I think that people that do what I do, we do this a lot because it's not uncommon. The FMLA and the ADA are so complex. But when an employee calls in for an intermittent FMLA, they have a responsibility to identify the issue, the specific issue that they're having that's resulting in the need for the FMLA. Again, that gets overlooked a lot. They need to report that to HR because we don't want them calling and sharing their private health information with, anyone who answers the phone at the company. And then we're going to pull out those FMLA forms that we got that the doctor hopefully filled out, the doctor, and we're going to say, okay, you have FMLA for migraines, right? And you can use that 2 times a week, up to 3 times a month. And it looks like you've already used it 3 times this month, so you're not eligible. So this is going to count against you as a point, or whatever. It's an unexcused absence. Or I notice now that you have a migraine condition, but you called in and said that it's because of your back. Well, you're not qualified for FMLA for your back. But now I need to have a conversation with you because do we have another serious health condition
Correct.
that you may need FMLA for, or an ADA accommodation? So, it's just so important that the people that are handling this are properly trained. And again, if they're not, it can be burdensome. Get a third party administrator involved, or have someone like myself, or maybe even, this is something, Chris, if this is in your wheelhouse, outsource to an HR advisor who has the time and the skill set to review. Because spending that little bit of time reviewing these documents, making sure that procedure is being followed, does so many things. It tells your employees they're not going to get away with abusing the process. And for those employees who really need it, they're getting what they need. You're making sure their needs are met. And it's saving your company so much money in having people be accountable, showing up to work. You're avoiding lawsuits because you're treating everyone fairly. You have the right process in place. It's a big picture issue that has to be properly addressed.
I agree.
With the organization.
By the way, I don't know if both of you know this, but the passage of the FMLA was the catalytic event for SHRM to get involved in government affairs.
I did not know that.
Yeah, they didn't have government affairs before that. They did after. And when they were rationalizing this to the membership, they basically said, you can see the way it's written. You can see, because we knew it was going to be, every HR pro knew it was going to be a nightmare, right?
Yeah.
And they said that this would have never been written this way. Not that the bill wouldn't pass, but it wouldn't have been written this way had HR been in the position to influence it.
Yeah.
Right.
And it's really funny though, but I think that sometimes the HR personality is not always, seems a little bit more risk adverse than, so it's just funny that we do have the government affairs, because it just seems as if HR likes to learn about what's going on and the updates, but I don't know. It's just, it just seems really
put it
interesting to me.
I will tell you that I have, I would say the folks who were pushing FMLA at the beginning were well-intentioned. Right. Okay. I'm not.
Because you have to know HR, but of course they wanted to help people.
Dispersion. They also didn't know anything about the workplace or how this would actually hit or anything like that. And it was evident in its design. And technical correction to the FMLA has been the holy grail for SHRM since it was passed. And you'll notice that we haven't had any. There could be really no greater argument, right, for getting involved than something like that, right? And back when I was director of government affairs, I can't tell you how many bills I testified against in committee plenty of times, and I was very specific about what my concerns were, super specific, right? And I got questions from legislators and stuff like that, and far more often than not, I was able to get that shifted. Right, because they didn't understand it. They didn't know what that would mean, and that's the cost of silence. You don't.
The FMLA, it's a lot, and I think it's a great reason why we have to get involved, because that was because I worked for my I've said before, my HR experience was in public sector HR.
Yeah.
And I felt like I was researching everything constantly. You know, I was just nervous all the time because I would catch things because I was working on my APHR. And then I was catching things that we were doing in the office. And I was just like, oh my God, we're not allowed to drug test everybody. And it was just like, and I started to get anxiety because even with the FMLA, they weren't allowing the people to have FMLA. They just kept saying no. So I had to come up with a process. And it was just like, oh my God, this is like very stressful, looking to make sure that you have the right dated document, because that's the one that'll get you when you see like you have the old form. It was the most stressful, but what I found is that it was hard finding support, especially in public sector HR, because it seems like a lot of people in the HR world are more private HR.
Well, yes, that's true.
And it didn't
we always have to remember. We always have to remember.
It's 4:40. Do you have to go, Chris?
I gotta go here pretty soon. But
okay, then real quick, because I wanted to ask you, HB 1069 though, if it would have made it all the way through, is that something that we would have, really? Okay, so it's something. Okay, I just wanted to see, like,
there's nothing good in that. They're just okay. I understand. Put it this way: if I see it from the employee side, okay, so I'm not. I can see it from their perspective, but for all the things that Rachel and I outlined, that in practice that would be yield nightmarish results than positive results. So
okay.
Okay. Well, I'm gonna bounce and and class. So I will see you both at the next program.
Okay, and then of course you let me know, Chris. Anything comes up, we can jump on. Okay.
Thanks. Bye-bye.
All right.
So I was going to add. Okay. I think the most my employers call sometimes, and they're surprised to learn how broad the FMLA is, and just kind of to carry on the FMLA conversation, because I think it's something that HR professionals deal with every single day, right? It's so relevant and something that is so complex, and you often, even me as an attorney, sometimes I find myself digging through the regulations going, that can't be right. And one of those situations, I was looking at an intermittent FMLA situation, and when it's reasonable, and I kind of went down this rabbit hole and started looking into like public transit in Chicago and rail transit, and whether those operators are allowed to take intermittent FMLA. And the answer is yes. It is protected for them. They can literally be driving the L through Chicago, stop and say, I need intermittent FMLA. You need to bring somebody here to replace me. Or driving with a bus full of people and pull over and say, I'm taking intermittent FMLA for whatever my healthcare condition is. Get off the bus and make somebody else come. So, that is how much power people have when they are utilizing FMLA. Now, there are some exceptions where you can say, as an employer, whatever this role is, your intermittent FMLA is just such a burden on us that we can put you in another role. But it's got to be another role that they're qualified for. It can't be like a demotion, right? And when you're looking at someone that's like a bus operator or a rail operator in that organization, there's really not other positions available for them to do when the whole organization is based on operating a bus, or so
yes. So what do they do?
So they're just stuck. Another employee, and they replace them, and they let them continue. They don't have a choice. And so if I could change anything about the FMLA, it would be that when you have a position like that, a job like that, that's really important. You're transporting a lot of people, hundreds of people, maybe thousands of people who have somewhere they need to be. The doctor, work, picking up their children. That those operators are not eligible for intermittent leave. Now, I mean, they can go get another job. We can put them on extended leave, but the intermittent leave just does not make sense in certain positions. The burden
So
is
are
there.
they able to do that? Are
No.
employers able to do that? Okay,
No,
no, they're not.
not
They
right
still
now.
have to find a way to make it work.
Unless you have a position available that you can put them in while they're on the intermittent leave. Again, that's not like a demotion, something that's maybe a desk job or not as imperative, that they be present all the time, which many positions require. So,
Well, so you were saying that you would suggest that maybe, it's just intermittent FMLA is just not, and I think it makes sense. With government affairs, I've been doing a lot of research on just, how did employers come to be those that provide benefits in the way that they do today? And it just seems like when it first started, it was something that employers did because they wanted to win the best person, right? Like it was something that they did on their own. Now that it's become mandatory
yeah.
in a way,
Well, many
so I can
employers
totally understand.
not or would not if they didn't have to. And I'm not suggesting that the intermittent leave be done away with, completely. Only that when you are in a job where your, constant presence is imperative to the function of the job, that there be, an excuse from that. When you as the employer can show that it's unduly burdensome, kind of the same test when we're talking about whether an accommodation is reasonable, right? We give employers the ability to make that decision and work with an employee to determine whether a requested accommodation is reasonable, but we don't give them that power when we're looking at intermittent FMLA. And it doesn't seem like it would be a far stretch from my perspective to do that. And maybe that's something, that should be considered. It would have to be at the federal level though, because it is a federal protection, right?
Oh, so it would okay. So it's not something that we can take on here in Indiana.
No. I mean,
okay.
We could work with our congressman, with Jim Banks and, try to lobbying.
Todd Young.
And Todd
Yeah.
Young. Yeah. But
now, who did you say before that?
Jim Banks.
Oh, Jim Banks. Okay, yeah. Okay, so the other bill that I was looking at, I don't know if you've had a chance to look at that one, the expungement.
Oh yeah.
And
I saw that.
And the only reason why I was looking at that one, because I just thought, like, is this something that HR people would be aware of? Because I know when I would do background checks on people, there were certain things that, we would see, but then if it didn't really apply to the job, we wouldn't, acknowledge that. But does this have anything, like, do HR professionals, does this mean anything to us? Because it is moving forward. It didn't die.
So I can't tell based on what I'm looking at here what it actually does. So repeals and replaces the existing adult expungement statute with a new expungement process that makes changes to time periods, crimes that are eligible, and other procedural matters. But I don't know what those are. Do you know what they are?
Okay.
1, 2, and 3? Because then it says it adds a provision concerning the expungement of juvenile arrest records. But again, I don't know what that is. So I'm not sure if they're talking about expanding it or constricting it. Are they wanting to make it, I guess, let's say, so the way it stands right now, if you are committed or convicted of a misdemeanor, you have to wait 1 year from the conclusion of any like probation or anything like that, and then you can file to have it expunged. And then the law goes on to outline other crimes and the different levels of the crime, and then depending on the crime and the level of it determines how long you have to be separated from your final probation, parole, whatever it is, before you can request the expungement. And then there are certain crimes that can never be expunged. Certain sex crimes, I want to say, okay. I think bribery.
Okay.
So again, I'm not sure what the goal is here, but
okay. And I'm looking at the bill, but I would need ChatGPT's help.
That's okay.
to understand.
I'll take a look at it
Exactly.
for the next session. What I can say generally, though, about the expungement statute and its relation to employment is that once a crime is expunged, it cannot be considered in when making employment decisions. So if it's expunged, you should know about it. It should not come up on the.
So I shouldn't have even seen it. Okay.
Right.
Okay.
But if it does,
so then
and sometimes they do. Sometimes they don't do a great job of clearing it from certain records. Or you may find you may Google. So this is a very real situation that happens. Someone may have been convicted of a very serious crime, and they were convicted. There may have been news articles about it. And then they may have served time. And while they were in prison, they may have tried to file a habeas corpus petition to be released from prison or appeal their sentence. And those often are publicly released. The opinions from the appellate court, there may be additional news articles about that. And so when they get out, they've done their time, they've done all the things, they waited whatever the time period is, they're able to get it expunged. But if you Google their name, you may still, and I've had this happen, you may still find some of the other information about them that you didn't know about. And then there are some really interesting questions that come with that, because on their job application, did it say, have you ever been convicted of a felony? Right? And now you know they were convicted of a felony, but they answered no. What do you do with that? Well, the truth is that the no is an acceptable answer if the crime has been expunged.
Okay, because that's what I was. Okay.
Yeah.
Okay.
It is as if they had not been convicted. The only time that those expunged records can be used, I want to say, I know one of them is sentencing. So if they commit another crime and they are in front of a judge or a jury and they're now being sentenced for this other crime, now we can talk about what they've done in the past. And I think that may be the only exception. Sometimes maybe in family law, if there was something that was recently expunged, but it was a violent crime and you're talking about custody or something, you could maybe bring it up then. I'm not sure. Yeah.
Wow. So, but it is acceptable because, sometimes we talk about, is it justice? Ooh, what's the word? I can't but for people having a second chance, I'm always trying to, these labels sometimes throws me off, but for people who are looking, having a second chance, and being able to get back out there in the work, place, it's acceptable for them to say no if it's been expunged.
Right. Well, and this is something that I would not be surprised if this was proposed to make it easier, just using general terms, for people to get an expungement. And I say that because one of the executive orders from our governor when he, Mike Braun, when he took over his role, was to lower barriers for hiring based on criminal history. So that was something that he seemed to be passionate about, again, which was surprising. I think we talked about it on this podcast.
Yes.
Certainly not anything that he campaigned on, but he felt as though people were being, held back from gainful employment because of their previous crimes they've been convicted of. And when I'm advising my clients, I always encourage them to kind of ask themselves some rational, reasonable questions. Does the crime impact the job we're going to ask this person to do? Are we sending someone into people's homes? If so, okay, we care about theft crimes. We care about violent crimes, especially recent ones. We care about drug use. Are we looking at someone who's potentially a heroin addict or recently has meth charges? Because those people, especially if they're currently using, how long ago was it? And there's potential there for theft because we all know, drug addicts are looking for ways to. So those are things that we want to take really seriously. Is it a desk job and the person has a DUI from a couple of years ago? Do we really care about that? Is that really a big deal? I don't,
and
I don't.
And that's what it was. What I saw, it was just like, okay.
Yeah, definitely. Or maybe it was a drug charge, but was it 10 years ago? And has this person have a good work history since then? Does it seem as though they're in recovery? And that's a fair question to have with them. Hey, we see that you've got this. We just would like to talk about it. So let's have a conversation. Where are you at with this? Can you tell us what happened? It's okay to do that.
Okay, so you can have those type of conversations behind closed doors, okay.
Yeah,
Okay, super cool.
it's
Okay.
fair, and I would encourage people to do that because it gives the employee the opportunity to say, yeah, I had a problem 10 years ago, and I went through recovery program, and I've been sober for 8 years now, and really improved my life, and hopefully what I look for if I'm participating in those interviews is some ownership, right? I don't want excuses. I like it when people are honest and say, yeah, I made a mistake. But here's where I'm at today. That's a whole lot better than, oh my gosh, I got, it wasn't me,
like
somebody
those
else's.
suckers. Yes.
Yeah. So
then
that gives you some insight into their integrity too, a little bit. So
now, would you say that this is like their second interview sort of thing, that maybe you're calling them back in after the first interview, sort like is this when they're hired? Would you say that you're having this conversation, or an HR person?
I would want to know how serious. I think it's very fact specific, right? It's very specific to the crime, because if it's a serious crime and you're really concerned, I do it in the first interview, because that's going to tell you whether you're going to have a second interview at all.
Okay.
If it's an old DUI, maybe you don't need to ask anything, period, or a conversion charge from 15 years ago. They were, 19 and they shoplifted something from Kroger. Probably not a big deal, right? But if it's a serious crime, I would probably encourage you to do it from the beginning, because again, I think how they answer those questions and where they're at today and how they explain that is going to be really important moving forward for you. So
then this is great, because now I'm just like going down the rabbit hole of this. So does it provide and I know we have just a few more minutes, but does it does it create a risk for the HR, for the company, if this conversation is had and then it's later decided that you're not going to move forward with this person? Is there anything to fear?
Sure. Here's the pitfall,
okay.
Right?
Okay.
And this is where companies get in trouble, and people often think that there are legal protections for felons. There are not in the state of Indiana. Some states do have those protections.
Okay.
The reality is African-American men are at substantial higher risk for having felonies on their records. We can get into the reasons for why that exists. Very often it's drug charges. Some people would say there's over policing. There's a lot of things that you can talk about, and you can approach it from
in that. Yes.
It becomes political. That's not appropriate for this podcast.
Yeah.
But,
well, if I have another podcast, I'll where I'm talking about it, I'll definitely bring you on to.
Okay. So all that said, what you have to be careful about is that you're treating these fairly. So it's good to have policies in place that say we're willing to hire people with these crimes, and maybe they're the level of the conversion, the DUI, whatever, as long as they're 3 years old. We're willing to consider hiring people that have drug charges, other nonviolent crimes that are over 5 years old. If you can justify, and this would be an internal policy, if we believe that the crime was a one-off and they have recovered, and they have a good job history after that. We do not hire people with violent crimes ever, or it's got to be 20 years old or something. I had a client who the original background check failed to show a manslaughter charge. And we did not, the employer just did not hire felons, period. They really liked this employee. This employee had served 20 years, got out, and someone within the facility figured out, oh, this is that guy who had committed this murder, basically. And
okay.
They had to fire that person. But it was a difficult decision for them because they felt like the employee was doing a really good job. They felt like they had served their time, but they had this policy. And so we have to make sure, that we have, and you know what, if you want to make exceptions for that, that's okay, but you need to change your policy, right? And so maybe you're willing to hire manslaughter, I don't know, if it's over 20 years old. In that case, this person was interfacing with the public and children, and so it just too risky. We can't do it, right? But there are some situations or some positions where it may be, it may be okay. So I see
that's super cool.
I do have to get going. So
okay, yes. Well, thank you so much, Rachel. I had a great conversation with you and Chris today. Definitely, we'll check in any new topics, and until next time.
Okay, great.
All right, bye.
See, have a great.
You too. All right, we're gonna head on out. See you guys next month.